Hey, it's Mark here, and welcome to the next edition of the Employee Survival Guide, where I tell you, as always, what your employer does definitely not want you to know about, and a lot more.
Welcome to another episode of the Employee Survival Guide, produced by employment attorney Mark Carey.
Glad to be here.
So today we have a really fascinating case to get into. In 2006, a driver for a major delivery company finds out she's pregnant. And instead of, congratulations, she gets basically a masterclass in corporate legal loopholes.
Yeah, a harsh reality check.
Right.
Yeah.
We are looking at this wild scenario where a guy who temporarily loses his driver's license because of a DUI conviction, by the way, gets handed this nice, cushy inside desk job to keep his paycheck flowing. But a pregnant woman doing the exact same work, she gets shown the door and stripped of her medical insurance.
I mean, it sounds like a premise designed specifically to make you furious.
Totally.
But it's actually the real factual foundation of a completely defining 2015 Supreme Court case.
Yeah.
Young v. United Parcel Service, Inc. It's exactly UPS. And our goal today with these sources, which include the majority opinion, a very specific concurrence, and a couple of highly charged, really spicy dissents, is to understand how the highest court in the country grapples with one single, highly ambiguous sentence in a federal statute.
Just one sentence.
Just one. And we're going to look at how the interpretation of a few stray words directly alters the daily reality and honestly the financial survival of pregnant workers everywhere.
Yeah, because when you're talking about a seemingly neutral corporate rule, you really have to see how it falls apart in practice on the warehouse floor. Which brings us to Peggy Young.
Right. Let's talk about Peggy.
So she was a part-time delivery driver for UPS. Her specific job was picking up and delivering packages that arrived via air carrier.
Which is heavy work.
Very heavy. And well, after suffering several miscarriages, she became pregnant again. So her doctor gives her this really clear, incredibly standard medical restriction. Basically, do not lift more than 20 pounds for the first 20 weeks of the pregnancy and no more than 10 pounds after that.
Which, makes perfect medical sense.
Right, it's standard. But that recommendation collides head-on with UPS's blanket job requirements because their drivers had to be able to lift up to 70 pounds and assist in moving packages weighing up to 150 pounds.
Ow.
Yeah. So because Young couldn't meet that strict physical requirement, UPS told her, well, you can't work.
They just benched her.
Exactly. They forced her onto unpaid leave for the duration of her pregnancy. And, to make matters worse, that forced unpaid leave eventually caused her to lose her employee medical coverage right in the middle of a pregnancy.
Which is just devastating.
Unbelievably stressful. So, okay, let's unpack this for a second. Because on the surface, a logistics company having severe physical requirements for a physically demanding job makes, total sense.
Sure, and you have to move heavy boxes to work at a shipping company.
Right. But the issue is never just the rule itself. It's how the company applies the exceptions to that rule.
Exactly.
Imagine you've got a bouncer at an exclusive club, right? And he strictly enforces this no sneakers dress code.
Okay, I like this analogy.
So he lets in a guy wearing sneakers because the guy says, hey, I sprained my ankle. But then he turns away a pregnant woman wearing sneakers who says she needs the arch support.
Right, so the rule isn't the problem, the selective leniency is.
Exactly. The bouncer is selectively applying the leniency. And our source material shows UPS actually had a really robust, light-duty alternative work program. They just, heavily restricted who was actually allowed into it.
And the specifics of those exceptions are exactly what turned this into a massive Supreme Court battle.
Yeah.
So UPS offered light duty to 3 specific categories of employees.
Okay, what were they?
First, drivers who were injured on the job. Second, drivers with disabilities formally recognized under the ADA. And third, drivers who had lost their DOT, that's Department of Transportation certifications.
Now that third one, the DOT certification category, that is where this gets wildly uneven.
It really does. Because you can lose a DOT certification for a vast array of reasons that have absolutely nothing to do with listing boxes.
Right.
The sources note you could lose it for a medical condition, like, say, high blood pressure, or a sudden sleep apnea diagnosis. You could even lose it because your driver's license was suspended after a DUI conviction.
DUI?
Yes. And if any of those things happened, UPS would find you an inside job. They would accommodate you. But for a pregnant woman with a temporary lifting restriction, the UPS occupational health manager explicitly told Young she was, quote, too much of a liability.
Oh, man.
and told her she could not come back to work until she was no longer pregnant.
Too much of a liability. I mean, that specific phrase from the warehouse floor basically kicks off this massive legal war over intentional discrimination versus, like, rigid neutral policies.
Yeah, it's the catalyst.
Because Peggy Young didn't just accept the unpaid leave. She fought back. She sued using the Pregnancy Discrimination Act of 1978, the PDA.
And to really appreciate the power of the PDA, you have to understand the historical absurdity that forced Congress to write it in the first place.
Well, this part is just nuts.
It really is. So back in 1976, there was this Supreme Court case called General Electric Company v. Gilbert. GE had this comprehensive disability plan for its employees that covered almost everything. I'm talking sports injuries, elective cosmetic surgeries, hair transplants.
Hair trans.
Literally.
Yeah.
But it specifically excluded pregnancy. And the Supreme Court at the time actually agreed with GE.
They sided with the company.
They did. They ruled that excluding pregnancy wasn't sex discrimination because, in their view, pregnancy was just an off-the-job physical condition.
The Supreme Court legally classified human reproduction as something akin to like voluntary nose job rather than a fundamental biological reality. It is just staggering to think that was the law of the land.
The Congress thought so too, thankfully. So they quickly passed the PDA to overturn that Gilbert decision, and they added 2 critical clauses to Title VII of the Civil Rights Act.
Okay, let's break those down.
The first clause simply clarified that discrimination because of sex absolutely includes discrimination on the basis of pregnancy, just putting it in black and white.
Right.
But the second clause, that is the battlefield for Peggy Young's case. It states that pregnant women shall be treated the same for all employment-related purposes as other persons not so affected, but similar in their ability or inability to work.
Treated the same. I mean, those 3 words basically force the Supreme Court to weigh 2 totally, completely polar opposite interpretations.
Exactly.
So Young's legal team advanced what the court labeled the most favored nation argument.
Which is a great name for it.
It is. They basically claim that if UPS provides an accommodation to any subset of workers, like, say, the guys with sleep apnea or the DUI convictions, then they are legally obligated to provide that exact same accommodation to pregnant workers.
Right. And then on the other side, UPS pushed this theory of absolute neutrality. They argued that their policy treated Young exactly the same as anyone else with an off-the-job injury.
Like the bouncer treating everyone without sneakers the exact same way.
Precisely. They said, look, if a UPS driver throws out his back lifting his kid at home over the weekend, he doesn't get light duty either. So UPS claimed that because pregnancy happens off the clock, treating it like a weekend sports injury is perfectly neutral and therefore not discriminatory.
But wait, I have to play devil's advocate here. Looking at the exact letter of the law, doesn't UPS actually have a point?
How so?
Well, the statute says pregnant women must be treated the same as other persons. If UPS treats pregnant women exactly the same as guys who bust their knees on a weekend ski trip, aren't they technically following the text? Like, why should a pregnant worker get a light-duty desk job when the guy with the busted knee doesn't?
It's a fair question. But the Supreme Court tore into both of these extreme positions because both of them lead to totally unworkable outcomes in the real world.
Okay, how so?
Let's look at Young's most favored nation concept first. If the law unconditionally guarantees pregnant workers every single perk given to any other employee, the whole workplace hierarchy basically collapses.
Oh, I see.
Yeah. Suppose an employer offers lighter duties, specifically to workers who do extra hazardous jobs, or to older employees who have been with the company for 30 years as a seniority perk. Under Young's interpretation, a brand new employee who gets pregnant would instantly be entitled to those exact same senior level perks.
Right, which Congress almost certainly did not intend. You can't just elevate pregnant workers above every other neutral seniority-based rule in the American workplace.
Exactly. So that's why Young's interpretation was way too broad. But the court threw out UPS's defense, too.
Because of the Gilbert case.
Yes. UPS's argument essentially deletes the second clause of the Pregnancy Discrimination Act from the history books. If a company can legally say, we treat pregnancy just like any other generic off-the-job injury, they are bringing the workplace right back to that 1976 Gilbert era.
Right, where pregnancy is treated like a hair transplant.
Exactly. The entire reason Congress wrote the PDA was to stop employers from lumping pregnancy in with weekend sports injuries.
Okay, so both interpretations are dead on arrival, which means Justice Stephen Breyer, who was writing for the majority, had to engineer some kind of middle path.
He had to find a compromise.
Right. He needed a mechanism for a worker to prove discrimination without demanding that most favored nation status. And to do this, the court pulled this old, heavy-duty legal framework off the shelf, the McDonnell Douglas test.
Yeah, the McDonnell Douglas framework. It exists because of a very practical problem in employment law. I mean, bosses rarely send emails that say, hey, I'm firing you because you were pregnant.
Right. Nobody writes that down.
Nobody writes it down. Direct smoking gun evidence of illegal bias is almost impossible to find.
So the courts created this burden-shifting test. Think of it like a circumstantial trap to force employers to reveal their true motives. And the court adapted this test specifically for pregnancy in 3 steps.
Okay, let's walk through the steps because this is where the mechanics of the law get really interesting. The first step is the prima facie case, right? Which is essentially the employee's opening move.
Yeah. You have to prove 4 basic things. You belong to a protected class. You asked for an accommodation. The boss said no. And this is the crucial part. The boss did accommodate other people who were similar in their ability to work.
And Young easily cleared that initial hurdle. I mean, she was pregnant. She asked for a 20-pound lifting restriction. She was denied. And she pointed directly at the coworker with the DUI who was handed a desk job.
Boom. Step 1 done.
Right. And that immediately shifts the burden back over to the company for step 2, the employer's defense. UPS now had to provide a legitimate, non-discriminatory reason for denying her light duty.
And the Supreme Court set a massive boundary here, didn't they? They explicitly ruled that a company cannot simply claim it is more expensive or less convenient to accommodate pregnant women.
That's huge. Cost and convenience are completely off the table as excuses.
Which is wild because that's usually a company's go-to excuse.
Exactly. But let's say the employer offers a valid, neutral reason. Maybe they argue, well, we only offer light duty for on-the-job injuries because we have to comply with specific state workers' compensation laws.
Okay, that sounds legitimate on paper.
It does. And if they do that, it brings us to the third and final step, pretext. The burden shifts back to the employee one last time. And she gets a chance to prove the employer's neutral excuse is actually just a cover-up for discrimination.
A pretext.
Yes. And Breyer introduced a brand new standard for this specific stage. He said an employee can prove pretext by showing that the company's policy imposes a significant burden on pregnant workers, and that the company's reasons just aren't strong enough to justify that burden.
A significant burden. So applying that to Peggy Young's reality on the warehouse floor clarifies everything because she gathered the data and she showed that UPS accommodated a massive percentage of non-pregnant workers with physical limitations. The sleep apnea cases, the high blood pressure cases, the suspended licenses. But at the exact same time, they categorically failed to accommodate a massive percentage of pregnant workers. So by revealing this stark systemic imbalance, Young proved that the burden fell incredibly heavily on pregnant women.
And the Supreme Court ruled that this looked suspicious enough that a jury really needed to examine it. So they threw out the lower court's ruling against her.
Which is a huge victory. But the impact of that ruling stretches way, way beyond Peggy Young's paycheck, doesn't it?
Oh, absolutely. The majority essentially handed pregnant workers nationwide a powerful new circumstantial tool. You no longer need an email proving your boss hates pregnant women.
Thank goodness.
Right. You can use your company's overall track record of bending the rules for other people as evidence of hidden discrimination against you. If the data shows a significant burden, you have a case.
But, and this is where the drama really comes in, this complex, burden-shifting compromise infuriated several members of the court. I mean, the concurring and dissenting opinions are where the legal philosophy gets really sharp. You had justices basically accusing the majority of acting like a legislature and just inventing laws out of thin air.
Yeah, the ideological divide here is fascinating to read. So first you have Justice Alito. He wrote a concurrence.
Meaning he agreed Peggy Young should win.
Right. He agreed she should win, but he fundamentally disagreed with Breyer's new 3-step balancing test. Alito kept his focus entirely on those DOT certifications. He looked at the reality of the business and stated that UPS had absolutely no plausible neutral reason to treat drivers who lost their DOT certifications better than pregnant drivers.
So for him, it was just common sense.
Exactly. For Alito, it wasn't about weighing significant burdens or making a new framework. It was just obvious, clear-cut, disparate treatment. He didn't think the court needed to invent a complicated new test to see that.
Okay, but then you have Justice Antonin Scalia, who took it much, much further in this fiery dissent, which was joined by Justices Kennedy and Thomas. And, I mean, Scalia did not hold back.
He never did.
No. He openly mocked the majority. He called their new significant burden test inventiveness, posing as scholarship.
Ouch.
Right. But Scalia is famous for strict textualism.
Yes. And textualists believe a judge's only job is to read the exact words on the page. You don't try to guess what Congress intended, and you certainly don't build elaborate balancing tests to fix a poorly written law.
You just read the words.
Exactly. So Scalia argued that the Pregnancy Discrimination Act simply means pregnancy discrimination is sex discrimination, full stop. If a company has a truly even-handed policy, meaning they only accommodate on-the-job injuries, and they apply that rule ruthlessly to everyone, male or female, pregnant or not, then denying a pregnant woman is not discrimination.
It's just equal misery under a neutral rule.
Exactly. Equal misery.
I mean, he actually used the word poof in his dissent to describe how Breyer magically conjured up the new legal standard. He literally wrote, poof. The law now says you have to weigh significant burdens against sufficiently strong justifications.
It's so dismissive.
It is. But he was sounding an alarm. He was arguing that when judges mash together these policy compromises because they don't like the harsh outcome of a literal reading of the text, they are essentially stealing power from Congress.
And that is a profound critique of the judicial system. Scalia is warning against the danger of judges acting like politicians.
But is Scalia right? I mean, on a practical level?
Well, that's where Justice Kennedy's separate, very brief dissent adds a really crucial layer of societal reality to Scalia's strict logic, because Kennedy agreed with Scalia on the rigid textual interpretation of the law.
Right, he signed on to it.
He did. However, Kennedy felt compelled to write separately to acknowledge the real-world stakes. He pointed out what he called the pervasive presumption that women are mothers first and workers second.
Wow. So Kennedy is essentially saying, look, the strict wording of the law forces me to rule against Peggy Young, but I recognize that this creates a massive systemic injustice for women in the American economy.
Yes. And it perfectly captures the tension at the heart of the Supreme Court. Because laws are fundamentally messy. When Congress writes a vague phrase like, shall be treated the same, it rarely maps cleanly onto a complex modern warehouse floor where people are dealing with DOT certifications, union rules, and workers' comp.
It's just not that simple in real life?
It's not. So the majority felt forced to build a pragmatic, functional framework just to make the statute workable in reality, even if textualists feel it totally violates the strict boundaries of the text.
So what does all of this legal maneuvering actually mean for you, the listener? I think the takeaway is that the laws protecting you in the workplace are not just static words printed in a textbook. They are actively shaped and stretched and defined by real people like Peggy Young who are just fighting to keep a paycheck and their medical benefits. And they are defined by judges constantly negotiating the tension between the strict letter of the law and the messy reality of human biology.
And it is also really important to view this case through the lens of timing, because the events with Peggy Young happened before the 2008 amendments to the Americans with Disabilities Act.
Oh, that's a great point.
Yeah, those amendments significantly expanded the legal definition of disability to cover temporary physical limitations, such as pregnancy-related lifting restrictions. So the legal landscape has shifted considerably since Young's ordeal, offering much broader potential protections for pregnant workers today under the ADA framework, rather than having to rely solely on the PDA.
Which leaves us with a really fascinating thought to consider. Because as our legal definitions of disability and workplace accommodations continue to broaden, will we eventually reach a point where the specific cause of a worker's physical limitation, whether it is a pregnancy, a weekend softball injury, or simply just getting older, ceases to matter entirely to employers?
That's the million-dollar question.
Right. Or will human nature and, corporate bottom lines ensure there will always be an invisible hierarchy of who gets the good accommodations and who gets sent home without pay? It's definitely something to keep in mind the next time you look at the employee handbook at your own job. Thank you so much for tuning in. We'll catch you on the next one.
If you like the Employee Survival Guide, I'd really encourage you to leave a review. We try really hard to produce information to you that's informative, that's timely, that you can actually use and solve problems on your own and at your employment. So if you like to leave a review anywhere you listen to our podcast, please do so. And leave 5 stars, because anything less than 5 is really not as good, right? I'll keep it up. I'll keep the standards up. I'll keep the information flowing at you. If you'd like to send me an email and ask me a question, I'll actually review it and post it on there. You can send it to Carey at capclaw.com. That's capclaw.com.